Greetings, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Coming at you again tonight with some more of this brief on the research that I've been doing. And tonight we're going to get on to a judicial element, the forum shopping and stuff that they do. And if you look in the comment section, it says not a judicial nor a non-judicial prisoner under scrutiny of anyone. When they do their forum shopping, what they're doing is they got a judicial system, a territorial overlay, you might say a web, just like covering everything on the territorial aspects. These are multiple different jurisdictions that they can play in, and they get to shop in those forums. These are all extensions of the exclusive jurisdiction, which is extended from the post office for whatever they post to the accounting for those jurisdictions, each and every separate one. And each and every separate one is supposed to have an agreement, an interlocal agreement with the post office to be able to operate that jurisdiction. It's called foreign trade zones. And again, this is relative because of that address that's attached to the building. So let's take a look at it as we've got here. From LII Wex. This is forum shopping. Forum shopping refers to the practice of pursuing a claim subject to concurrent jurisdiction. Concurrent, meaning there's two jurisdictions going on in the court that will treat the claim most favorably. In other words, they can pick from two or multiple jurisdictions. That's what the concurrent, there are multiple jurisdictions in the court that will treat the claim most favorably. Forum shopping can occur between courts in different states, between federal and state courts in the same state, or between courts in separate countries. While forum shopping is still permitted under limited circumstances, the practice is generally discouraged in the modern legal system due to the Erie Doctrine and other conflict of law rules. Under the Erie Doctrine, which was explicitly adopted to reduce forum shopping, a federal court sitting in diversity jurisdiction must apply the substantive law of the state in which it is sitting. As a result, a plaintiff cannot use forum shopping between federal court and state court within the same state to choose which laws will govern the merits of their claim. Plaintiff cannot use forum shopping between federal court and state court within the same state to choose which laws will govern the merits of their claim. Now, the merits of the claim is much like the concurrent jurisdiction, in that the merits of the claim is telling us that there's a superior jurisdiction to their administrative and judicial courts. These administrative courts that are operating the judicial forums, there's a merits of their claim. What are the merits? Do they ever mention the merits of a claim in a court? Why are they always asking, do you understand the nature and cause? Because nobody's mentioned the merits of the claim. No, I don't understand the nature of cause because I believe there's a variance from categorical pretreatment standards that are fundamentally different in nature, and that is your credit system is manual and my credits are spiritual. I want to take a minute real quick to remind everybody, please hit that like, share, and subscribe button. There's PayPal links down in the chat for anybody, or in the details section for anybody who wants to share some love. And the StreamYard link is down there for anybody who wants to join. So what do you think, Russ? What do you know what the difference is between manual credits and spiritual credits?
Well, I would say it comes from the spiritual side of things, and versus the form, which is the letter.
Absolutely, absolutely. So when they talk about this federal acquisitions regulations 48 CFR 52.212-5, the contract terms and conditions required to implement the statutes or executive orders hyphen commercial items, we're talking about the paper documentation rather than the spoken word.
Right.
And that's why we have to remember that in the beginning was the Word, and the Word was God, Word was God. If you really want to bring truth to anything, you've got to know the truth, and the truth is going to sit in the words. If you see a document before you and you think you understand those words and everything, you might think again. You might want to really do some earnest work on that and go back and relearn what's being said. We have D Nose here. Welcome, D Nose.
Greetings.
Greetings. Thanks for having me up, Keith.
Anytime. You've been listening in as we talked about that forum shopping definition.
Yeah, a little bit. Because when you're trying to go to the StreamYard, it kind of takes you away. So I missed the last few minutes because I was trying to get my stuff together.
Well, basically, it talks about the Erie Doctrine, which is something that they enacted to try to dissuade people from forum shopping. But yet there's multiple forums, so it's not something that they can't do. It's just something that they urge them not to, because if somebody like me comes along and catches them with all of these summary judgments, proving that they are missing elements to make any kind of final judgment, because there's a definition we're going to take a look at here in a short called declaratory judgment.
Yeah, they've been talking about the declaratory judgment on lawful living a lot lately.
Yeah, I haven't been on there much, but I'll have to get back in there and give them a shout out. But
no, it's an interesting strategy, though.
Well, yeah, it's something I recognized on my case, or on all my cases. The only thing they ever gave was a summary judgment. This tells me that they never moved on to the next phase, which is a declaratory judgment, which is something that is part of the process to a final judgment. And so if they've only got a mere summary judgment, then there's something seriously wrong with the record as opposed to be finalized. It's not. Every last one says a summary judgment.
Well, the idea of the declaratory that they're talking about is to get the courts to admit that their own rules say A, B, or C, and how that doesn't apply to you. And by having them declare that you don't qualify along those lines, makes it much easier to prevail against them.
Well, yeah,
that's the idea.
That's kind of like the admissions and omissions. Admit or deny.
Right. Well, I got prosecutors telling me they're not going to answer my damn questions. Hell, I got a response from the Department of Justice saying, "Yeah, your complaint may or may not have merit, but we're just too busy. We're not going to do much. We're not going to do anything about it."
Well, and see, there's a problem. And see, there's a problem when you attack personal jurisdiction, when they try to say, yeah, they got personal jurisdiction. Well, first of all, I would have had to have received a summons in the mail in the state in which the court sits And that summons would have had to include also a waiver that I could sign waiving personal jurisdiction. If this court doesn't have both a summons and that waiver attached and a handwritten statement of intent certifying my waiver, then there is no personal jurisdiction. They have a fatality.
They're doing straight slave work these days, dude. I'm trying to call them
Oh, I
on that,
know.
and it doesn't seem to work. They don't
know,
want to
I know.
acknowledge.
Yeah.
It's pretty
So let's
crazy.
get back to it here. Where am I at here? So, additionally, the court's ability to decline to exercise their jurisdiction through the power of forum nonconvenience prevents plaintiffs from using forum shopping to burden the defendant by choosing to sue in a highly inconvenient jurisdiction. Nonetheless, even with the Erie Doctrine and other restrictive measures in place, a plaintiff may still find it beneficial to engage in forum shopping. For example, a plaintiff suing a large corporate defendant might choose to sue in a state court rather than federal court because they believe that a local jury will be more sympathetic to their argument than a federal jury. Alternatively, a plaintiff might prefer one jurisdiction over another due to a quirk of its procedural rules or due to its conflict of law rules. Some plaintiffs deliberately structure their state law claims against out-of-state defendants to prevent the out-of-state defendants from removing the case to federal court, which might otherwise have diversity jurisdiction under 28 USC 1332, which is the diversity, citizenship, and claim. Diversity of citizenship, amount and controversy, costs. For example, a plaintiff using a major retailer might sue both the national parent company and its local store. By joining the in-state defendant, the plaintiff prevents federal courts from exercising diversity jurisdiction over the case for lack of complete diversity. And that's why I mentioned that the merits. Under the merits, there are variances from fundamental or from categorical pretreatment standards that are fundamentally different in nature, causing complete diversity. Therefore, the concurrent jurisdiction with the state is the federal Supreme Court in the state for that diversity jurisdiction for federal removal. They're using an extension of a United States citizen known as a resident. They cannot claim their forum shopping. You take it straight to federal court. The next one is INTA Bulletin. Now, INTA is the International Trademark Association. Why are we talking about International Trademark Association if we're talking forum shopping? Because that's what the forum shopping is all about. Where are you going to advertise that name? Does that make sense?
Absolutely.
Dean just got booted, so if you want to come back up, feel free to hit that link again. We're still here, of course. But yeah, that's what they're doing is they're advertising that name. It's an investment. And as long as you claim the United States, they're going to claim the investment powers of the United States. They're going to do it at the state level as if though you're a servant because the state, United States, contracted you to the state. That's what that residency is. It's a United States citizen that no longer lives in the United States and now resides in one of the states. That's the specific thing about a resident, is that you were on one side first and you recited to the other side. I was born in this fucking state. I'm not a resident. I was not born in the United States. There is no birth registry in the United States. So when it comes to the name and the enumeration, it's all about international trademarks. It is being used in the international markets. And if you think this internet and all these social sites and all of the data elements that you put in on those that they use in their advertising is not an international trading platform, you're wrong. And they will use every mark they can get their hands on. Let's read the first thing of this. A trademark practitioner charged with obtaining legal protection beyond national borders often is in a more comfortable situation than colleagues in many other fields of law. A system of international treaties and organizations supports the practitioner in transferring the client's rights from its home jurisdiction to others and enforcing such rights. So, as the practitioner, I myself, Keith Little, can transfer the client's rights, Keith Orland Little, the legal name, that is now merged as the Keith Orland Little FBU, and I can enforce them. How do I do that? Because I've got an international agreement with the Postal Service as an enterprise payment system trust account. All I need to do is have it funded. Let's look at the next one. I told you we were going to talk about that declaratory judgment. So, Dean, you're still around? A declaratory judgment is a binding judgment from a court defining the legal relationship between parties and their rights in a matter before the court. So if I have an express a enterprise payment system trust account and it's with the post office, isn't that under international law? Isn't there already a binding judgment defining that legal relationship? Isn't this what part of that is? This right here, the very definition of a declaratory judgment? When there is uncertainty as to the legal obligations or rights between two parties, a declaratory judgment offers an immediate means to resolve this uncertainty. Again, what is done is what ought to be done. There is nothing new under the sun. Why are you providing controversies? It's already made certain. Know the terms and know what they are. And
That's
if you don't,
vital.
yeah, and if you don't, and you don't see that there's something wrong with them, you're the one that's making it uncertain. However, because a declaratory judgment is often sought prior to the full development of a lawsuit, courts are sometimes hesitant to issue declaratory judgments as they would prefer to see the case develop more before issuing a judgment. Why? Because that extension is a contract in time where they get to keep working on the clock and just see more data elements. If there's a declaratory judgment set before the court, then let's make it more succinct. If there's a declaratory judgment set before the court that very distinctly and very certainly exposes the variances that make it inconsistent with law and an impossibility, then there would be no need for the state or the court to be hesitant in support of sustaining the state's budget. The court should be readily available and willing to accept such declaratory judgments by simple research upon the very basic facts presented, rather than trying to come conclusively with a bunch of mumbo jumbo clarifications of contract law and commercial terms and this and that. When you find various certain differences that, like I've expressed here, the merits, how come nobody's talking about these merits? So we're going to get into that here again in a minute, because again, this is as they would prefer to see the case develop more before issuing a judgment. There is no reason to have a case develop more before issuing a judgment if the judgment that you have put before you by an outsider, somebody that's extrajudicial and giving you supplemental information that is superior to the facts being presented as a fiction, then you really need to start thinking about this shit a little bit deeper. In typical civil actions, plaintiffs seek damages or injunctive relief to remedy an injury. In other words, there generally must be an injury for which a court can grant relief prior to a party bringing a lawsuit. Declaratory judgment actions are an exception to this rule and permit a party to seek a court judgment that defines the party's rights before an injury occurs. Before an injury occurs. This sounds like the first duty of law is legal notice. Hey, I'm just letting you know I'm going to be passing through your territory here, but I assure you I'm a stranger and sojourner with our Father which art in heaven, itinerant, coming along, coming through to teach people. Nothing more, nothing less. No commercial activities will be propounded. Declaratory judgment differs from other judgments because it does not provide for any enforcement or order a party to take any action or pay damages. Essentially, it states the court's authoritative opinion regarding the exact nature of the legal matter and whether the parties would be entitled to relief without actually requiring the parties to do anything. For example, a declaratory judgment action could be brought to determine party rights and obligations under a contract or to establish the validity of a patent. What do you think?
You know, I always go back to it blows my mind how simple this shit is. Even in consciousness, if you, uh, I,
Who has the right?
Go
Who
ahead.
has the right to put a value on anything but yourself? If it's your creation, you have the right to put a value on it, and that's what the declaratory judgment is. Do you have any valuables to declare? That's what they ask you when you come to the courts. Do you have any valuables to declare? That sounds like a pirate wanting me to let him frisk me before I get on his vessel, as if
Empty
though
out
he
your
just
pockets.
invited me, but he's going to frisk me. Say that again.
Empty out your pockets.
Yeah, yeah. And so the only thing I can declare is the truth. What is it you're looking for? Now they have to declare the truth. It's that simple. What do you have to declare? You got any valuables to declare? Yeah, I've learned very well to coin my purse or coin my lips or purse, coin my words or purse my lips. So I can only declare the truth. What are you looking for?
Yeah.
Well, we're looking for any weapons, cocaine, drugs. Nope, ain't got none. Don't know what those are. How could I have them if I don't know what they are? It's like the United States citizen. How can you be a United States citizen if you really don't know what it is? People go around declaring things that they really don't know. Been doing it for decades. So let's get on to the next one, because I told you we were going to talk about the merit system, right? Well, it might seem a little off track here, but we're going to talk about the immigration court. Detainee transfers and immigration judges. Remember yesterday we were talking about the burial transit permit, where you get to transfer the body from point A to point B to be buried. Detainee transfers and immigration judges. See, they're just talking about transits of bodies, and immigration judges. ICE forum shopping tactics in removal proceedings. We talked about the federal removal from state to federal. It's a removal proceeding. It's a removal from the administrative and judicial courts to a merits court, an individual calendar hearing. We're going to read about that. Under Georgia Law Review, Volume 53, Number 1, 2018, University of Georgia Law School of Law students. U.S. immigration policy and ICE tactics have been greatly scrutinized over the past year. While many criticisms focus on border policy and the conditions of detention, scholars have also raised concerns over ICE's unfettered discretion to transfer detainees to different detention centers. Not only may ICE transfer detainees anywhere in the country, ICE has gradually expanded this practice. Now, on average, every detainee is transferred at least once a year. ICE, however, is not the sole point of criticism for immigration advocates. Recently, immigration judges' decisions have been scrutinized for the lack of consistency. Wide variation in immigration judge decision making indicates that the judge assigned to a case heavily influences the likelihood of a favorable outcome to ICE. Okay? So the specific intent of the forum shopping is for favorable outcomes. Remember, these are contract courts, and you have to look for things in your favor. But there has to be equal consideration. That's why they have the Erie Doctrine. The intersection of these two distinct problems, immigration detainee transfers and inconsistent immigration judge decisions, effectively allows ICE to forum shop by transferring detainees to detention centers with IJs who are likely to issue rulings favorable to ICE. This amounts to a crisis of justice, as ICE may transform facially neutral proceedings into judicial rubber stamping for the case outcomes ICE desires. And as I said earlier, I'm not a judicial nor an extrajudicial prisoner, detainee, fugitive, or anything of the sort. Let's take a look at the next one, and this is the connection to the merits. This is Executive Office for Immigration Review, U.S. Department of Justice, Immigration Court Practical Manual, hearings before the immigration judges, individual calendar hearing, evidentiary hearings. Evidentiary hearings. See, we're not having a hearing to contest somebody's testimony, or we're here as an evidentiary hearing to look at the record. That's where the evidence exists. It's already there. We're going to do an evidentiary hearing and look at the record as set already. That's the asset. All it has to be done is wrung out so that all parties are made whole, settled. Evidentiary hearings on contested matters. Contested. This is the term I use whenever I draw up a document for somebody contesting the land grants, the titles, the warranty deeds. We hereby contest the record. Matters are referred to as individual calendar hearings or merits hearings. Individual calendar hearings. Individual. is the one that's born in the state and enumerated at birth. That is the individual. Again, it's an exclusive jurisdiction to each one of us that was born, and it establishes the state's vital statistics jurisdiction for that record. The individual's name and number identify the record. We're here to contest the record, and I know I can contest my record because I'm the one that put those data elements in there, and I know what's wrong with them. I now know that instead of telling them that I am the benefactor and that I have the given name and I hail from the family Little or Conrady as it is, and that I know the difference between that and the legal name, and I'm not qualified to operate the legal name in a corporate capacity because I do not have a board of directors in order to hire an attorney so that I could then represent that said legal name in one of those courts. It could possibly be developed, but I would only be in the development stages at this point, and I've chosen a different path. So I'm developing along the path of sovereignty, my own abilities to self-govern. That's all I'm doing. I'm not trying to fight anybody or piss anybody off or anything like that. My whole point in all of this is merely a correction of the record, making all parties whole, where no person shall be held liable in any court, because I think we're all fucking it up. And I think if we don't all turn around and change our ways, then the minds of hearts of the men that I see today will continue to degrade and degenerate future generations upon themselves, one after another. We need to start standing up to our own responsibilities and start doing what it takes. And that doesn't mean going out and protesting for BLM or protesting for transgender or anything. I mean, it's a matter of correcting the record. If you want to profess that you're transgender, that's fine, but don't put it in a fucking record. If you want to profess that you're this or that, that's fine. Put it in your own private journal. But putting it in their public record. Their public record is what they're holding against you. Don't you remember the Miranda rights? Anything you say can and will be held against you in a court of law. Anything you say or do can or will be used against you in a court of law. So keep saying and doing things that are going to be held against you in a court of law. Quit putting them in those forms so they can write them down and record them. If you don't do that, they can't use them against you. Fifth Amendment, the right to not incriminate yourself. I'm just a babbling idiot. I don't know what you're talking about. You can maintain that all you want. All I know is what God tells me. I don't even know English. All I know is what God tells me. You could literally hold that. You'd be all right. What do you think, Russ?
I think that's absolutely right. I mean, based upon your actions, it could be that simple. It literally could be that simple if you can hold those principles and standards.
Yeah, most people refuse to do that, though.
I know.
They want to claim that they have some kind of intelligence. They want that ego out there to let everybody know, hey, I'm the one that did that.
And you know, guys like you and Paul and everybody's just tried to share in their journeys and their experiences, and give people a faster track to the truth. And they just want to fight against it. And when they do get the truth, and you know it as well as I do, when they do get it, when they do figure it out, they'll figure out that they'll be doing the same thing that we're all out here doing now, because they'll realize that they can't protect their own. Right?
Yeah, that's what it comes down to. You know, um, the merits.
Yep.
It isn't just your spiritual credit, it's your spiritual power. See, a man that's able to rule his house and say, no, you won't touch my woman. No, you won't touch my children. I'll teach them. And I'll teach them much more than what you're ever going to teach them. Who can deny that? Who can say that I have to follow your curriculum, teach my children reading, writing, and arithmetic? I believe otherwise. I believe in letting them learn their talents naturally, and I guide them in that. And as time goes on, they will learn the reading and writing and arithmetics that go along with that.
That would even be a spiritual foundation as well. That would be much, much more valuable.
Well, yeah, when a man goes out, a child goes out and learns his talents, her talents. It's a plural. If you look at kids nowadays, this ADH thing is just hypocrisy.
Yes.
A child's mind is very developmental. It will develop quickly if you let it. It will develop much stronger if you let it develop the way it wants to, in its own talents, not in its own selfishness or anything. Again, you have to be able to guide them. You can't just let them go out and be footloose, you know. But in a good, proper guidance of structuring a child with a whip, letting him know that there's consequences, not literally beating him, but just letting him know that there's consequences and rewards, then he gets to choose in his talents how much he wants to achieve in those rewards, because only he can come to the imagination of his endeavors in that talent, whatever that talent is. He's the only one that sees the glory in his mind of being so great at something. Well, when we learn that we're not only just great at one thing, we can be great at many things, then we become much more objective to the reality that we have around us and seeing it for what it really is from different perspectives. One guy that might think he's a professional BMXer might very well be the greatest BMXer in his mind, but then comes along another guy that thinks he's the greatest BMXer, and now you got to have the objective view of a greater population and say, okay, well, we think. So what really is somebody else's thought about what your talents are? Again, I urge people to learn how to put their own talents in their own, or put their own value to their own talents. Do it for your own reasons. Yes, emancipation from global slavery. Absolutely. All right. Well, you got anything else to add on here, brother? Because otherwise, I think we're going to continue on. I've got, let's see here. Yeah, let me read this here first before we get out of here, because judicially, I am self-determined, independent, and neutral already. If you remember, the judicial officer department is a neutral and independent forum. I too, judicially, being self-determinate, am independent and neutral. I'm willing to negotiate. If you say it's worth this much and I say it's worth this much, maybe we can meet somewhere in the middle. But either way, one way or another, neither one of us is going to be accepting of accusations from each other from here on out. We come together in peace. If you can't do that, then stay the fuck away from me. And the last thing I wanted to mention before we did leave was the definition of extrajudicial from LLI Wex, Law Cornell. Extrajudicial refers to something that has occurred outside of or without the authorization of the judicial system. As such, it might not follow proper legal procedures or might not carry adequate legal authority. For example, an extrajudicial statement would be something said outside of the courtroom. Did you know the statement of live birth is such a thing? And it shows on that graph that it was from the informant and it was taken by the birth clerk and entered into a birth log. Like I've said before, that was an extrajudicial general journal that was then converted to a general ledger. taking it from extrajudicial and making it judicial. That's what we're talking about. So with that, thank you again, Russ, for showing up and being part of the board. Always appreciate your input. Dean, thanks for stopping up, and appreciate everybody that showed up in support. Again, hit that like, share, and subscribe button. There's PayPal links in the details section for anybody that wants to share some love. Remember, I love you. I don't give a rat's ass whether you love me back or not. So may God bless you. Have a good night, and we'll see you again next time. Bye now.
Peace and blessings.